Hello friends, this is Sanjay. In this 5-part video series, I have covered an overview or a quick revision of interpretation of statutes and principles of legislation as per the Karnataka State Law University, that is KSLU LLB syllabus. The syllabus is common for both the 3-year and 5-year LLB. In each part of this series, I have covered one unit from the syllabus. While I have included all the topics and concepts as mentioned in the syllabus for each unit, the order or the sequence of the topics may be a little different for better explanation. This is video 4, unit 4, Presumptions in Statutory Interpretation. The first question is, what are presumptions? Now, presumptions are the basic expectations with respect to the legislative intent and the operation of statutes. In simple words, presumptions are some basic expectations which are based on common sense and fairness and the principles of natural justice. These expectations or presumptions are used in every step of the interpretation of statutes. For example, if a statute is clear and unambiguous, then there is no need for interpretation. It should be implemented or enforced as is. If there is a need for interpretation, then the primary principles are applied first, such as the literal rule, the golden rule, etc. If required, the secondary principles are applied next to fine-tune the interpretation that was done through the primary rules. Now, these secondary rules are nothing but the Latin phrases that we discussed, such as redendo singula singulis, ejusdem generis. Here, the presumptions are applied at every step of the interpretation process. For example, there is the presumption of constitutionality, which is the presumption that the legislature would not have intentionally created any statutes to violate the Constitution. If a statute, as per its literal text, appears to violate the Constitution, then interpretation is required. When the primary principles are applied, and there are two or more possible interpretations of the statute, then the versions which violate the Constitution should be immediately discarded. Same with the secondary principles. After applying these principles, if there are multiple possible interpretations of the statute, then any version which appears to violate the Constitution should be ignored. Even while implementing or enforcing the statute, if there is any violation of the Constitution, then go back to step 1 and reinterpret the statute again. As I mentioned, these presumptions are based on some common sense and basic legal principles. And because the Constitution is the highest rulebook of the country, it is common sense and a basic legal principle that the legislature can make laws within the power granted by the Constitution and not violate the Constitution itself. In one of my other videos, I have briefly discussed an extensive list of 25 different presumptions in statutory interpretation. However, not all of them are included in the university syllabus. So here we will discuss in depth the presumptions that are specifically included in your syllabus. If you want to get an overview of all these 25 presumptions, I will include a link to that video in the description below. Presumption that statutes are valid. This means that the courts will always assume that statutes are valid and were made within the limits allowed to the legislation by the Constitution, and these statutes do not violate the Constitution itself. Now, the constitutionality of a statute is examined only where there is a particular need to do so or someone specifically challenges the same. For example, if the government makes a law that all forests should be cut and factories should be built on that land, and a suit is filed in a court by some person saying that he is eligible to get land for a factory and the government did not allot any land to him, then the court will examine and decide on that aspect only. As per the new law, was this person eligible to get the land? Why was he not allotted the land? And what is the relief that can be provided? The court will work with the assumption that the legislature has passed a valid statute. However, if someone files a suit or a PIL claiming that the law itself is unconstitutional, that is when the court will look at the constitutionality of the law. In a 2022 judgment, the Supreme Court laid down some explanation for this presumption. It said that statutes made by a competent legislation are valid till they are declared unconstitutional by a court of law. If a statute is declared unconstitutional, it will be as if it is not there at all, which means that the legislature cannot amend it or repeal it because it is not there, it doesn't exist. Only a new law can be passed. If some actions or transactions have happened in the past under the law that is later declared to be unconstitutional, then the court can choose to let those actions or transactions stand and overrule the legislation prospectively only and not retrospectively. If the declaration of a law as unconstitutional is leading to some injustice, then the court can provide relief. For example, if a person paid the government a large sum of money for getting the forest land allotted for a factory, and later that law itself is declared unconstitutional, then the court can rule that the government should refund the money and also pay interest on the money. Presumptions that statutes are territorial in operation. In general, central statutes are applicable across the entire territory of India, and state statutes are applicable within the territory of the state whose legislature made those statutes. If the central legislature intends that a particular statute should not be applicable in any particular state of India, then the same should be specifically mentioned. For example, before the abrogation of Article 370, most statutes would mention that they are not applicable in the state of Jammu and Kashmir. Also, if a statute applies outside Indian territories, then that also should be specifically mentioned. For example, the Bharatiya Nyaya Sanhita specifies situations when it will be applicable outside Indian territories also, such as when an offence is committed by an Indian citizen outside Indian territories, or when an offence is committed by any person, whether the person is a citizen of India or not, but the offence was committed on a ship or an aircraft that is registered in India, even if such a ship or aircraft was outside Indian territory when the offence was committed. Or a person commits an offence targeting a computer resource located in India, then the BNS will be applicable on such a person wherever the offender may be located across the world, and whatever may be the citizenship of the offender. Presumption as to jurisdiction. Here the courts will presume that a statute has jurisdiction over all matters or on all persons within the territory, unless the statute specifies a limitation or an exception. For example, the courts will assume that the GST Act is applicable on all goods and all services across India, unless the Act itself or the rules made thereunder allow for some limitations or exceptions. And if you look at it, the rules under the GST Act do allow for some exemptions to small and petty businesses or on specific items like agricultural produce where GST is not applicable. Similarly, the courts will assume that the Indian Forest Act is applicable uniformly across India, unless there are any specific limitations or exceptions that are mentioned by the government. And if you look at it, the Indian Forest Act does allow for some exceptions in the context of tribals, especially in states like Nagaland and Mizoram, where there may be some customs and traditions that may conflict with the statute. So, the statute provides some exceptions. Presumption against what is inconvenient or absurd. This is a presumption based on common sense that the legislature will not make laws to intentionally create inconvenient or absurd situations. For example, if there is a road which says one way for all vehicles, a very strict and literal interpretation of the law or the rule may say that even kids on tricycles are not allowed on that road. But the courts will work with the presumption that such absurd situations were not the intention of the legislature which created the law. Therefore, kids who are riding tricycles might not be punished for violating the one-way rule. Presumption against intending injustice. Here, the courts will presume that the legislature does not intentionally enact a statute that leads to an injustice or unfair results. Of course, most laws may lead to some kind of inconvenience to some people. But the primary aim of the law will be a greater good or a greater benefit to a larger number of people. So, while interpreting any statutes, the courts will first try to minimize the injustices or the negative consequences of the law. For example, in the 1980s, there was a situation where the authorities wanted to evict the people who had occupied the footpaths or encroached on public lands in Mumbai. Obviously, the intent behind evicting the people from the footpaths could be that the occupation of the footpaths was leading to pedestrians having to walk on the roads, and this was leading to a lot of accidents or traffic jams. Or it could even be that the occupation of the footpaths was negatively affecting the businesses in that area. So, the clearing of the footpath was for a greater good of a larger number of people. and it was being done as per the law. This is when a journalist called Olga Tellis, who was working with the Indian Express at the time, filed a petition on behalf of the pavement dwellers, challenging the eviction on the grounds that it was violating the right to life and the right to livelihood. In the judgment, the court held that while the law is correct and the action under the law is also correct, evicting people during the monsoon season was an injustice, and ordered that the evictions should happen only after the monsoon season had ended. Presumption against impairing obligations or permitting advantage from one's own wrong. Indian courts assume that the law does not allow individuals to benefit from their own wrongful acts or unfairly escape any obligations. There are several examples of this presumption from the area of contract law. For example, some exporters engaged with a cargo agency to send some containers by ship. The normal expectation is that the cargo agency will take all due care to ensure that the cargo is delivered safely and in time. However, to save some money and to increase his profits, the cargo agency owner intentionally chose a ship that was in very bad shape. It was rusting, it was not certified, and it was not approved as seaworthy by the authorities. And this person knew of all the risks and still chose that ship. On that particular voyage, the ship encountered some rough weather, which is normal, and any other ship in decent condition would not have faced much difficulty. But since this ship was already in a bad condition, it got damaged and it sank. Now, it was the cargo agency owner's wrongful decision to cut corners and intentionally hire a ship that was already in bad shape. He intentionally took that risk, which eventually backfired. So now, the courts will not allow the cargo agency to use this pretext of sinking of the ship to escape its obligations. The cargo agency will be held liable to make good on the damage that is caused to the parties whose cargo was lost. Presumption regarding the prospective operation of statutes. Typically, Indian laws are interpreted to apply to actions or to transactions that occur after the law takes effect, rather than affecting those actions or transactions that took place before the law came into force. For example, if a law was passed on the 1st of December of 1999 that smoking in public places is a punishable offence, and the law comes into force from the 1st of January of the year 2000. Then people who are caught smoking in public places on or after the 1st of January of 2000 can be prosecuted and punished. But people who were smoking in public places on 31st of December or before should not be prosecuted or punished. In other words, laws are generally assumed to be applicable only on actions or transactions that occurred after the law came into force, that is, prospective operation, and not retrospective operation. Article 20 of the Constitution specifically prohibits the retrospective operation of criminal laws. So, a person cannot be punished for doing something that was not illegal before the act came into force. A point to be noted here is that the Constitution does not prohibit the retrospective operation of civil laws. Therefore, civil liabilities can be enforced or taxes can be levied on past transactions. However, if there are any penal provisions, that is punishments, in that civil law, these penal provisions cannot be enforced retrospectively, that is on past transactions or on past actions. With that, we will end this video. If you have any questions or feedback, post a comment below, and I will see you soon in the next video. Take care and Jai Hind.